Hello, everyone. Let's talk about Circular 230 ethics today. Let's talk a little bit about the history of Circular 230 before we go into the meat of the circular that basically governs our profession, right? We're going to talk a little bit about Circular 230 history first. So, Title 31 of the United States Code was first published as the Horse Act of 1884, signed by Chester A. Arthur, the 21st President of the United States. Now, the reason why this is important, I know we were like going back to like high school government class, right? This is probably the last time you ever heard the name Chester A. Arthur, right? But he was the 21st President of the United States. And this was actually before the income tax existed. This was before the income tax. And Circular 230 is actually part of Title 31. Now, the history of enrolled agents dates back to 1884 when that Horse Act was passed. And in 1884, the Internal Revenue Service was not yet in existence. There was no Internal Revenue Service in 1884. Now, the Horse Act stipulated that, quote, enrollment was governed by a committee on enrollment and disbarment that was meant to ensure that enrolled agents, attorneys, and other persons representing claimants could help settle claims associated with property the government had seized for use in the Civil War. And specifically, this law was passed in order to allow citizens to make claims against the U.S. Treasury for the value of horses, basically the mode of transportation at that time. People had horses that were confiscated for use by the troops during the Civil War. Okay, so that's basically how Circular 230 came into existence, how enrolled agents came into existence. They were basically representing people or helping to represent people before the U.S. Treasury Department so they could get some money back from the U.S. Treasury Department when U.S. troops basically, took their horses that were seized during the Civil War. Okay. Now, the first income tax in the United States wasn't actually passed until 1913. So several, decades later. And what happened at that time is the scope of the enrolled agent, their duties, was expanded to include claims for monetary relief for citizens whose taxes had become inequitable. Ethical standards. Now, ethical standards for enrolled practitioners are promulgated by the IRS as well as state governmental bodies. The IRS sets standards for enrolled practitioners in Circular 230. In addition, the AICPA sets guidelines for CPAs at the state level, and the American Bar Association sets out standards for attorneys. With regards to enrolled agents are bound by Circular 230. We have to follow the rules and regulations in Circular 230. And then with regards to CPAs and attorneys, they are also bound by the rules in Circular 230, but they also have guidelines and standards of practice that are issued by their state governing bodies. So CPAs and attorneys are licensed by the state, and then enrolled agents actually are licensed by the Department of the U.S. Treasury. So it's a federal license. But all enrolled practitioners are bound by the rules and regulations of Circular 230. Let's talk a little bit about best practices for tax advisors. Tax advisors or tax professionals should provide clients with the highest quality representation concerning federal tax issues by adhering to these best practices. You must communicate clearly with the client regarding the terms of the engagement. For example, if a client hires you to represent them during an audit, or if a client hires you to file 5 years of delinquent tax returns for him or her, or if the client hires you to respond to an IRS notice, you have to communicate clearly regarding the terms of the engagement, which generally means you should have them sign an engagement letter. Now, engagement letters are not technically required by the IRS, but they're always a really good idea. I always recommend that you use engagement letters because I can't tell you how many times I've heard of situations where the client will come back and say, how come you're not doing XYZ for me. I thought I was paying you for that. And they don't realize that what you were going to provide for them was tax preparation. But they also want you to do, a full year of bookkeeping. But that wasn't part of the engagement. You need to really make sure that that is outlined explicitly, the terms of your engagement with that client. Generally, it should be in writing. You should make sure that they sign that engagement letter, because this type of misunderstanding is very common. Usually it has to do with money, because money can be a touchy subject. But, they have to know what you're going to be providing for them in terms of services, the terms of the engagement. They have to know. So you have to communicate clearly. That's your job. That's your job. It's your job to communicate clearly with the client the types of services that you're going to be providing for them. Establishing the facts, determining which facts are relevant, evaluating the reasonableness of any assumptions or representations relating the applicable law. Okay. Advising the client relating the import of the conclusions reached, including, for example, whether a taxpayer may avoid accuracy-related penalties under the Internal Revenue Code if the taxpayer acts in reliance on the advice. Sometimes taxpayers will approach you with a question. They want tax advice, and they really want to hear, what they want to hear. They want to hear the answer that they've already thought about in their head. They want to deduct something. Maybe the answer that you give them is not the one that they want to hear. You have to make sure as a tax practitioner that when you do give tax advice to a client, that you are basing your tax advice in fact, relating it to applicable law. Whatever tax law will apply in that case, you have to make sure that the advice that you're giving to the client is genuine tax advice that has a basis in fact. You can't just tell a client what he or she wants to hear in order to obtain that client. You have to make sure that you establish the facts and that your tax advice, the advice that you do give clients, has a reasonable basis in the applicable law. And then the last on the list is acting fairly with integrity in practice before the IRS. You always have to maintain a professional demeanor with the Internal Revenue Service, with their employees, with their customer service representatives. I know sometimes it's difficult, especially lately, because the IRS is understaffed, and sometimes we do have to wait on hold a long time on the practitioner priority line, or when you're trying to get in touch with collections or whatever. But you do have to maintain a professional countenance at all times with the Internal Revenue Service and the employees of the Internal Revenue Service, even if you get frustrated sometimes. So you always have to maintain a professional demeanor. There are people too, just like us, and they have to deal with a lot. They have to deal with a lot, just like we do. So you have to try to remain professional at all times, and you have to act fairly and with integrity. So no being a fibber, no lying to IRS employees or anything like that. Okay, always have to be professional. All right. Now, Circular 230 has 4 main subparts. Most of what you will hear when people are teaching ethics courses or when they're talking about Circular 230 are these first 4 subparts on the list, which are Subpart A, the authority to practice, Subpart B, duties and restrictions relating to practice before the IRS, Subpart C are sanctions for violations, basically what the IRS can do to you when you get in trouble. Subpart D, disciplinary proceedings. And then the last subpart is just general provisions. And this section contains like miscellaneous procedural rules. But these first 4 on the list are the main subparts of Circular 230. And that's what we're going to talk about in this webinar today. Now let's talk a little bit about OPR. OPR's authority and responsibility. This is the Office of Professional Responsibility. This is the governing body of the IRS that's responsible for matters relating to practitioner conduct and is responsible for discipline including disciplinary proceedings and sanctions. So if you get in trouble as an enrolled agent or some other tax practitioner or enrolled practitioner, it's going to be OPR that that issues disciplinary proceedings and sanctions. Okay? OPR's mission is to interpret and apply the standards of practice for tax professionals in a fair and equitable manner. Now let's do our first sample quiz. The regulations governing practice before the IRS are set forth in A, Title 31, B, Title 26, C, Title 42, or D, the Internal Revenue Code. Choose the best answer, and I'm going to give you a few seconds to kind of decide. And the answer to quiz number 1 is A, which is Title 31. So regulations governing practice before the IRS are set forth in Title 31. Now let's talk a little bit about the OPR and RPO. Now, sometimes newer preparers will tend to get these two offices confused, but they are separate from one another within the IRS. The Office of Professional Responsibility, or OPR, has exclusive responsibility for discipline, including disciplinary proceedings and sanctions. The Return Preparer Office, or RPO, is responsible for the issuance of PTINs, acting on applications for enrollment, and administering AFSP testing and continuing education for designated groups. AFSP is the annual filing season program, which is a voluntary program that was implemented by the IRS after they kind of did away with the registered tax return preparer exam. Okay, so that's the AFSP program, which is an annual program. According to IRS publication 5637, the OPR receives more referrals from RPO than from any other IRS organization. So these two offices will communicate with one another, and the Return Preparer Office will make referrals to OPR if they encounter a situation where a practitioner is not complying with Circular 230. Now, according to that same publication, publication 5637, historically, a substantial majority of the OPR's cases fall into the following 3 case types. So when there's a referral to OPR for practitioner misconduct, most of the cases have to do with these 3 things. So compliance. These are cases involving one or more alleged violations of Circular 230 that are directly related to the practitioner's disregard of personal and or business tax compliance. This means the practitioner's own tax returns, which seems shocking to me. And but I know it happens because practitioners can get disbarred for this. And every year, you know, the disbarments those are public. You know, they're published on the IRS website. So you can search the practitioners that have been disbarred in any particular year. And many times, I mean, certainly more often than I would have imagined, it happens, the disbarment or the, you know, censure or whatever kind of discipline the OPR decides on for that particular practitioner, it happens because the practitioner themselves is not filing their own tax returns, which seems crazy to me. I mean, I know we're all busy, right? Everybody's busy during tax season, but you know, I file an extension every year. And when, you know, once you get past April, usually there's a little bit of time in there right around June or August that you can, like, you know, file your own tax returns. But apparently this is pretty common. So compliance issues are one of the main reasons for OPR referrals, where tax practitioners can get in trouble because they're not filing their own personal and business tax returns. You got to make time to do your own tax returns at some point during the year. You know, I file an extension every single year since I since I became an enrolled agent. I've never filed before April because I'm just too busy. But I always manage to file before October 15th or at least on the deadline, if not before. Now, conduct are cases involving one or more alleged violations of Circular 230 that are unrelated to the practitioner's level of tax compliance. So sometimes that will be situations where they might have some other legal issue going on. And then there's hybrid, which are cases involving multiple alleged violations of Circular 230, some of which are compliance related and others which are conduct related. Firm compliance. Now let's switch gears a little bit. We're going to talk about firm compliance. Now, any practitioner who has, or practitioners who have or share, principal authority and responsibility for overseeing a firm's practice of preparing tax returns, claims for refunds, or other documents for submission to the Internal Revenue Service must take reasonable steps to ensure that the firm has adequate procedures in effect for all members, associates, and employees for purposes of complying with Circular 230. Now, this really doesn't affect sole practitioners. Like if you're like a one-man show or a one-woman show and you don't have any other employees in the firm that are actually preparing tax returns, then this is not as much of a concern because you just need to worry about yourself. But many firms are multi-preparer firms, especially if you're talking about something like a chain, like a franchise, like H&R Block or Liberty Tax, or any of those types of franchises generally will have multiple tax practitioners working in the same firm. The practitioner who is basically the owner of that firm, or whatever practitioner has the principal authority and responsibility for overseeing that firm's practice, has to make sure that the firm itself has adequate procedures in effect for all of its employees. Basically, if the owner of the firm or whatever practitioner has the principal authority for that firm, usually we're talking about the owner, right? The owner of the firm. If they don't make sure that all of the employees are complying with Circular 230, then they can be subject to penalties, even if you have a situation where maybe you have like a rogue employee that's doing things that you don't know about, like filing fraudulent EITC claims or something like that. The IRS's position is that as the owner of that firm, or the practitioner with the principal authority of that firm, you have to know, or you have to be aware of what your employees are doing. Okay, and this rule can apply even if it's a situation where it's two partners in a firm, like two equal partners in a firm. Now, with regards to firm compliance, any practitioner who has, or practitioners who share, principal authority will be subject to discipline for failing to comply with the requirements of this paragraph if. Now, what they mean here with regards to practitioners who share is that you can actually be subject to disciplinary action or disciplinary proceedings, even if it's a situation where you're sharing authority with another tax practitioner, and that tax practitioner is, for example, filing fraudulent returns or inflating deductions on clients' returns. Even if it's not you that's doing that, then you could still be subject to sanctions if you have a partner or some other practitioner in the office that's sharing authority with you and he or she is doing that. Now, the practitioner can be subject to discipline if the practitioner, through willfulness, recklessness, or gross incompetence, does not take reasonable steps to ensure that the firm has adequate procedures to comply with Circular 230, and one or more individuals who are members of, associated with, or employed by the firm are or have engaged in a pattern or practice in connection with their practice with the firm of failing to comply with Circular 230. Now, what they're talking about here with the pattern or practice, they're not talking about a situation where you just make one mistake. If you just make one mistake, even if it's a doozy, then that's just one mistake. What happens with OPR is they really are looking for patterns or multiple situations where you have willful disregard of the rules of Circular 230. Filing false claims, inflating deductions, that sort of thing. That's a pattern of conduct. Let's say maybe even what we were talking about in the previous slide, where the tax practitioner is not complying with their own filing obligations. Filing one tax return late, or maybe you have a situation where you have an e-file failure and you don't realize it, so you file your own tax return several months late, but it's a one-time thing. That's not going to generate a referral with OPR. You're not going to get in trouble for one mistake. But what the OPR is looking for is a pattern of conduct where you are repeatedly failing to comply with the rules of Circular 230, or you are turning a blind eye to what's happening in your own firm. You're willfully ignorant of someone else in your firm not complying with Circular 230. Now, the second paragraph here states also that the practitioner can be subject to discipline if the practitioner knows or should have known that one or more individuals who are members of, associated with, or employed by the firm are or have engaged in a pattern or practice in connection with their practice with the firm who does not comply with Circular 230, and the practitioner, through willfulness, recklessness, or gross incompetence, fails to take prompt action to correct the non-compliance. My understanding of this is that you really have to be aware of what's happening in your own firm, especially if you have partners or employees, or even something like independent contractors. I think that this paragraph here is going to cover all of those things. It's not just going to be employees. For example, if you have independent contractors and they're using your software and they're filing false returns or they're inflating deductions, then you could potentially be subject to discipline for that too. You have to be really aware of what's happening within your own firm. Now, let me give you two examples of firm compliance. Basically, these are examples that are based on guidance from the IRS website. I just added names. These are not real people or anything. Okay, example number one. Roger and William are both CPAs, so enrolled practitioners, and they are partners in an accounting practice and prepare hundreds of tax returns every year. After reviewing a few business returns that William has prepared, Roger thinks that his business partner, William, might be advising his clients to take credits for which they do not qualify. Roger decides to say nothing and does not confront William about his suspicions. If the firm is later audited by the IRS, Roger may be sanctioned by the IRS for William's negligent or reckless actions. Now, William can get in trouble too, for sure. But Roger, the implication is that Roger saw this happening. He should have known what his partner was doing, and both of them can be subject to sanctions because of this, even though it's only William that's actually inflating deductions. Okay, so this is part of the firm compliance rules that applies to Circular 230 practitioners. You have to know what's going on in your own firm or in the firm that you're a partner in. Okay, example, Catherine is an enrolled agent working for a tax practice. Catherine knows that her coworker is filing fraudulent EITC claims but does nothing. Catherine can be subject to sanctions because she knew that other members of the firm were committing EITC fraud and she did not report the illegal activity. Okay, so she could get potentially sanctioned or in trouble because she's not reporting this illegal activity, but she knows that it's going on. Okay, she does nothing or says nothing. So it's really important that as enrolled practitioners that you don't turn a blind eye to this sort of thing. Now, sample quiz number 2. Which IRS office has responsibility for matters relating to practitioner conduct, discipline, disciplinary proceedings, and sanctions? Answer A is the Taxpayer Advocate Service. Answer B is the IRS Examination Division. Answer C is the Office of Professional Responsibility. And answer D is the Return Preparer Office. So I'll give you a few seconds to kind of decide which one you think it is. The answer to quiz number 2 is C, which is the Office of Professional Responsibility. Now let's talk a little bit about IRS information requests. This is when the IRS is requesting information, generally during the audit process or the examination process. Not always, but most of the time that's when you're going to see an information request as a practitioner. So under Circular 230, when the IRS requests information, the practitioner must comply and submit records promptly. A Circular 230 practitioner must, when requested by the Director of Practice, also provide the Director with any information he or she may have concerning a violation of Circular 230 regulations by any person. So if the IRS is investigating, a client or another preparer, and they request information from you as a Circular 230 enrolled practitioner, you are also required to comply and submit any information that you might have. Now, there's an exception to this duty, and that is made if the practitioner believes in good faith and on reasonable grounds that such information is privileged or that the request is of doubtful legality. FATP confidentiality privilege. There is a specific code section, it's IRC section 7525, that allows enrolled practitioners and their clients a limited right of confidentiality protection. Now, when we're talking about this code section, we're talking only about federally authorized tax practitioners. This code section, IRC 7525, applies primarily to attorneys, CPAs, enrolled agents, and then also to enrolled actuaries and enrolled retirement plan agents with regards to their area of practice, which is usually retirement plans. These are people who are enrolled to practice before the IRS. They do have practice rights before the IRS. And this limited confidentiality protection applies to communications that would be considered privileged if they were between the taxpayer and an attorney that relate to non-criminal tax matters before the IRS, so basically civil issues, or non-criminal tax proceedings brought in federal court by or against the United States. So the confidentiality privilege, for example, if you are an enrolled agent or a CPA, is only going to apply to these two types of tax matters. If you have a client that you believe does have, for example, criminal exposure, like criminal tax fraud, something like that, then that's when you need to get an attorney involved, or you need to refer that matter out to an attorney. Because in that case, if you are a CPA or an enrolled agent, you do have a limited confidentiality privilege, but you would not have confidentiality privilege with regards to criminal tax proceedings, because only an attorney would have confidentiality privilege with a criminal tax matter. You got to know when to bow out, right? You got to know when to walk away. And and sometimes with clients, you have to learn how to trust your gut. If you get that feeling like, this guy is doing some really shady stuff, or if it's a tax protester, you usually don't want to be dealing with those people. So in that case, you want to refer them out to an attorney and make your life a whole lot easier and go on to another client that's not going to give you this kind of problems. With regards to this limited confidentiality privilege, this privilege is not going to apply in connection with promotion of a tax shelter. So if there's a tax shelter anywhere involved, then this confidentiality privilege is not going to apply, this limited confidentiality privilege. And it also cannot be asserted by a taxpayer in matters before other regulatory bodies in an administrative or court proceeding. For example, a state taxing agency or any other government agencies. I've had other tax practitioners ask me specifically about this, especially with regards to state taxing agencies. Like, for example, in California, it's the Franchise Tax Board. The Franchise Tax Board deals with California income tax matters, both for entities as well as for individuals. California also has the BOE, which is the Board of Equalization, which is sales tax matters. So for example, if you have a business that sells products, then you have to remit the sales tax that's collected to the BOE. And then California also has the EDD, which is the Employment Development Department. Those are all state agencies that you might have to deal with if you're running a business in California, or if you're a tax practitioner helping your clients in California. With regards to this confidentiality privilege, for example, if your client has a business and they go under audit with the BOE for sales tax, okay, not income tax or any other tax, but let's say they get in trouble because they're not collecting and remitting sales tax the way that they should. In that case, you would not be able to assert a confidentiality privilege based on this code section, this federal code section, with regards to your representation of the client before the BOE, if you do choose to represent your client. So this particular confidentiality privilege under this code section only deals with the IRS. Okay, you can only assert this confidentiality privilege with the Internal Revenue Service and not with any other state taxing agency or with any other government agency. For example, let's say you have a client who gets in trouble with the Department of Labor because they're misclassifying workers. Sometimes the Department of Labor will come in and do a worker classification audit. Sometimes the IRS will do this too. They work together, those two agencies. You wouldn't be able to assert this confidentiality privilege with the Department of Labor because that's not the Internal Revenue Service. So this confidentiality privilege doesn't apply to any other agencies, okay? Now, a confidentiality privilege belongs to the client, not to the practitioner, and only the client can waive it. You as a practitioner always have the option to refer the client to someone else or to fire the client if you feel like you cannot represent them in a certain matter or if it's something that you don't deal with in your practice. Now, let me give you an actual example of this. This is based on a real case, which is United States versus Rad Chick. And this is a situation where we have a CPA, it's a licensed CPA, who tried to assert this confidentiality privilege with an IRS revenue agent. Example, Daniel and Jasmine Bernstein filed a joint tax return that was selected for audit. The IRS revenue agent assigned to the case suspected that the Bernsteins may have had foreign bank accounts and tax shelter activities that were not properly reported, right? So when you have a foreign bank account, most of the time that means that the taxpayer has to file FBARs, and they also have to declare that they have a foreign bank account on Schedule B, which is why we always have to ask all of our clients, do you have foreign bank accounts? The IRS also suspected that the Berensteins had participated in tax shelter activities that were not properly reported. So tax shelters are not always illegal. The IRS watches them very carefully. But if you do participate in a tax shelter, that's something that you have to actually declare. A lot of people don't do that, which is how they get in trouble. So tax shelter activities are not necessarily illegal, but the IRS does watch tax shelter activities very closely for abuses. And if you do have a taxpayer that does participate in tax shelter, they have to report that on their tax return. The IRS believed that this couple was not reporting their foreign bank accounts or their tax shelter activities. So the IRS issued an administrative summons, and a summons is a legal summons. You have to respond to it. The IRS issued an administrative summons to the couple's accountant, Ivana, who was a licensed CPA. So this was a licensed certified public accountant. Ivana responded to the summons, but refused to answer specific questions at her IRS interview, claiming tax practitioner privilege. This CPA attempted to assert that limited tax practitioner privilege. She's not an attorney, but she was a CPA. During the summons, she just basically refused to answer. Ivana also made no showing that she performed any work for the Bernsteins beyond tax preparation. The IRS took Ivana to court. So the IRS took the CPA to court to try to force her to comply with the summons and answer their questions. Ivana asserted in court that she had prepared the couple's tax return, but did not mention any specific tax advice that she gave that would qualify as privileged information. The court ruled that Ivana could not assert the tax practitioner privilege and ordered her to comply with the IRS summons. Basically, the long and the short of this is that she lost. She didn't want to tell the IRS anything, and the IRS was able to force her to comply with the summons, and she had to go through all this rigmarole, basically for nothing. I don't know if she ended up paying a lawyer to represent her or whatever, but this is an actual case. She tried to assert the confidentiality privilege in order to not answer questions with regards to her clients. She prepared the tax return. Maybe she was afraid that she was going to get sued by the clients themselves because she didn't report the foreign bank accounts or didn't tell them, hey, you have to report these foreign bank accounts and these tax shelter activities. You need to do this. Whatever the situation, she ended up having to comply with the summons anyway and answer the IRS's questions. So I think realistically, this is generally what is going to happen. The practitioner does have a federally authorized limited confidentiality privilege, but I think most of the time they're not really able to assert it. Maybe this CPA didn't do their job right, or maybe they just quickly prepared the tax return without asking about the foreign bank accounts or the tax shelter activities when they should have. So don't think it's going to get you out of trouble, basically, if you are an enrolled practitioner. And if you kind of sense that a person is doing something that they shouldn't be doing, or if they are involved in tax shelter activities and you're not really wanting to deal with that type of client, then you probably shouldn't take them on, or you should refer them out to someone else. Sample quiz number 3. IRC Code Section 7525 provides a limited privilege in what type of circumstances? A, non-criminal tax matters before the IRS. B, non-criminal tax proceedings brought in federal court by or against the United States. C, which is both A and B. And then D, criminal and non-criminal tax matters before the IRS. So I'll give you a couple of seconds to choose which answer you think is the best. And the answer is C, which is both A and B. This limited confidentiality privilege applies only to non-criminal tax matters before the IRS and non-criminal tax proceedings brought in federal court by or against the United States. Right. Let's talk about OPR discipline options. The Office of Professional Responsibility has a number of discipline options that they can take against an enrolled practitioner that has basically done something that they shouldn't have. The first discipline option is a reprimand. Now, a reprimand is private. It's not something that's published. Nobody else knows that it happened. Like, you wouldn't be able to look up a CPA or an enrolled agent that was reprimanded by the IRS because it's not published anywhere on the IRS website or in the Federal Register or anything. But it does stay on your permanent record. But this is like a private reprimand. The IRS is giving you a warning. A censure is kind of like a reprimand because it doesn't have any consequences against your ability to practice. But a censure, unlike a reprimand, is not private. So you can actually look up the practitioners that have been censured by the IRS. So this is a public reprimand. So a suspension will affect your ability to practice. So if you have an enrolled practitioner that is suspended, they cannot practice during their period of suspension. And suspensions can be for any amount of time less than 5 years, because a disbarment is 5 years. A disbarment is a minimum of 5 years. But many times the IRS will suspend a practitioner for a year or 2 years, but they could potentially suspend an enrolled practitioner for up to 5 years. But generally they don't do that. Usually it's a period of 1 year or 2 years. And you can look up these suspensions on the IRS website. I'm going to show you what it looks like when a tax practitioner does get suspended and when the IRS does publish this. So you can see how the names look and what kind of discipline has been imposed on that practitioner. There's disbarment, which is the most severe type of discipline that the OPR can basically mete out. Disbarment is a minimum of 5 years, which equals 60 months. Disbarred practitioners cannot practice during this time period. They can't practice at all. The only thing that they actually can do is prepare tax returns, and that's because of the Loving case. Hopefully we'll get congressional intervention at some point. I'm not holding my breath because Congress is busy doing other stuff right now. With regards to disbarred practitioners cannot practice before the IRS during their period of disbarment. So they cannot practice before the IRS for a minimum of 5 years. They can't file 2848s, they can't file POAs unless it's for something like a family member, for example, if I was disbarred, if I lost my license and I could no longer practice before the IRS because I had committed some felony and the OPR disbarred me, I wouldn't be able to practice before the IRS to represent a client, but I would still be able to practice before the IRS to represent myself, like if I went under audit, or I would also be able to, represent a close family member. Like I could represent my own minor child because I'm their parent. So the rules for limited practice would still apply in that case, but I would not be able to represent a client before the IRS, and I can't file the Form 2848. I can't file powers of attorney during my period of disbarment. The OPR can also impose monetary sanctions, and these monetary sanctions can apply to individuals and firms. OPR can impose a monetary sanction against an individual preparer, but also something like a firm, like a chain. Like if I owned an H&R Block and it was a corporate entity, my H&R Block is a C Corp or something like that, then OPR can impose a sanction against the firm itself and force the firm to pay a fine. Let me show you where the disciplinary sanctions can be viewed on the IRS website. The listing that's on the IRS website actually shows all of the names and the dates and all of the sanctions imposed since 1998, going back more than 20 years. So once your name is on this list, it's searchable for anybody to find. Okay, so you really want to try to avoid getting, public censure or a disbarment or a suspension or anything else like that, because your name is going to end up here and it's going to stay here because this listing goes back all the way to the 90s. So I'm going to show you a recent one. It shows the name of the practitioner, their professional designation, and then their disciplinary sanctions and the effective date. It also tells you the practitioners that have been reinstated. As you can see right here, this practitioner was reinstated to practice before the IRS, but just him being here, that he actually was suspended or disbarred or whatever in the past. So to me, I feel like that's bad. You don't want to be on this list. It tells you their names. It tells you the type of licensing that they have. A lot of CPAs, attorneys on this list. There's more CPAs and attorneys than there are enrolled agents. So it's not necessarily that CPAs get in trouble more or anything like that. There's just more CPAs in practice than there are EAs. But all of these names are public. This list is searchable on the IRS website. You can download these names. So I feel like you should try to avoid getting in trouble because you don't want your dirty laundry aired out on the IRS website. At least I think I wouldn't want to be on this list. I'll just tell you that right now. Now, with regards to criminal referrals, if criminal activity is suspected, like tax fraud or money laundering, the IRS can forward a prosecution recommendation to the Department of Justice Tax Division if it's a tax investigation, or the United States Attorney's Office for all other types of investigations. The Office of Professional Responsibility does not prosecute criminal cases. Basically, the OPR is not the one that's going to send you to jail if you are going to go to jail for some kind of criminal tax fraud or something like that. The OPR can disbar you, certainly, and they can suspend your license. But if it's a criminal issue, then the OPR would make a referral to the Department of Justice or the United States Attorney's Office. They're not going to prosecute criminal cases. They're going to refer that out to another government agency. With regards to OPR, if they do discover, maybe they're investigating a tax practitioner or a tax attorney for something else, and the examiner stumbles upon some kind of fraudulent activity, then the OPR would make a referral to the Department of Justice or the United States Attorney's Office, but they won't be prosecuting any kind of criminal case themselves. Now, let me give you an example of another real case. Okay, this actually happened. I changed the name a little bit because it kept coming up with a squiggly red line underneath because the Jonathan in the actual case was spelled a little funky. So his name is Jonathan spelled differently than this, but his name actually was Jonathan in this case. And this is an actual case. Okay, so Jonathan Perry, DBA Expert Taxes. So this is his fictitious business name. Okay. He prepared over 4,000 federal income tax returns during the 2017 through 2022 filing seasons. So he was really busy. Did a lot of tax returns during that time. In September 2023, a federal court in the Southern District of Texas permanently enjoined him from preparing federal tax returns for others and, among other things, from owning, operating, or franchising any tax return preparation business in the future. So he was barred by the court from preparing returns altogether, cannot prepare tax returns anymore. And then he's also not allowed to own a franchise or a tax practice in the future. He's not allowed to do any of that. The government alleged that Jonathan Perry significantly overstated the customer's tax refunds by claiming fictitious employee business expenses. This is like back when the 2106 was still something that you could use. Employee business expenses were always a fraud vector in the past. I don't know if this guy was still trying to claim employee business expenses on the 2106, even after the Tax Cuts and Jobs Act abolished it for most employees. But seems likely that he didn't really know what he was doing. He was fabricating household employee income. That's another fraud vector, household employee income, in order to basically generate EITC refunds when the person isn't actually working. They'll put in household employee income like they worked as a household employee, because in that case, it's considered a type of wage income, but you don't actually need a W-2. But it's a huge fraud vector. The IRS always looks for abuses there as well. And then fabricating or inflating business losses or claiming education credits or fuel excise tax credits to which customers were not entitled. So this is another type of common fraud that's done, right? It's always to get refundable credits for the most part. Tax preparers will create a fictitious business, a fictitious Schedule C where the person was not really self-employed in order to generate a false EITC refund or a false child tax credit, especially if the person has children. Because in order to claim the child tax credit, you have to have some type of earned income. You can't claim the child tax credit or the EITC if you're not working, if you have no earned income. So many times these types of fraudsters, they'll completely fabricate a business, or they'll say that the person is working as a household employee when they're not, that sort of thing. They always get caught. They'll get away with it for a couple years, but these people always get caught. And then what ends up happening is the IRS comes in and they will audit their entire client base. And they'll also go after the preparer themselves. So this is bad. It's really, really bad. The terms of the injunction order require that Perry disgorge. I use the same word that was in the case. Disgorge, right? He's got to pay it back. It's so weird that they use that that word, because I always think of disgorge as like something coming out of you, like vomiting something up. But the terms of the injunction actually use this verbiage. The Perry has to pay this back. He has to pay back $324,432, right to the dollar amount, to the United States in tax preparation fees. Basically what he made off of these false returns that he was filing for his clients. And then information about this case is available on the Justice Department's website. So this is the Justice Department's actual website. See, it says justice.gov. And you can look up the case if you are interested. But the link to the case actually says disgorgement. So I just thought that was weird, just that they would use that word. All right. So practice before the IRS includes all matters connected with a presentation before the IRS or relating to a taxpayer's rights, privileges, or liabilities under laws or regulations administered by the IRS. This is basically when you're representing a client. Okay. Most of the time, if you are going to practice before the IRS as an enrolled practitioner, it's either corresponding to a notice that the taxpayer has received. So most audits are correspondence audits, where the IRS sends the client a letter because they want them to either prove something that they've claimed on the tax return, or they want to verify something, or there's something missing. Many times it's a self-prepared return and the client has forgotten or left something off of the return that they needed to include. that they didn't. But practice before the IRS includes corresponding and communicating with the IRS, like drafting correspondence in order to respond to a notice. So that's considered practice before the IRS. If you represent a taxpayer at a conference, a hearing, or a meeting with the IRS, if you prepare and file documents with the IRS, with the exception of tax returns because of the Loving case, and then rendering written advice with respect to any entity, transaction, plan or arrangement, or other plan or arrangement having a potential for tax avoidance or tax evasion. So what they're talking about here is tax shelter advice for the most part. If you're actually rendering a written opinion or written advice with regards to some kind of tax avoidance activity or tax shelter activity. This is not an illegal act. I want you to understand that. It's not illegal for you to give written advice regarding a tax shelter. I personally don't do it. I don't do that. I don't offer written advice with regards to tax shelters. But if you do, if you decide to offer that as a service, then that is considered practice before the IRS. The taxpayer's representative. Now, taxpayers can always represent themselves during an IRS examination. They always can. They can represent themselves, but many times that's how they get in trouble, is they will attempt to represent themselves during an examination because either they don't have the money to pay a representative to represent them, an enrolled practitioner, or they think that they might be able to manage it on their own. Most of the time, they can't. They can't represent themselves very well. Taxpayers can always choose to use a qualified representative before the IRS. So taxpayers do not have to attend the audit if they have hired a qualified representative and the representative has a proper power of attorney authorization and is an enrolled practitioner under Circular 230. So for example, if you have a client that hires you and you're an enrolled agent, an attorney, or a CPA, and that client has signed the Form 2848 in order for you to represent them, many times the IRS examiners will say, oh, I want to talk to the client, or you have to bring in the client, or there's questions that I need to ask that client. They can't compel, the IRS can't actually compel the client to appear without an administrative summons. So the taxpayer doesn't have to attend, and it's generally recommended that they don't attend the audit if the representative has the proper power of attorney authorization and is an enrolled practitioner under Circular 230, or if the representative meets other qualified criteria, such as a certain family member of the taxpayer. So for example, once again, even if I wasn't an enrolled agent, even if I was not an enrolled practitioner, the rules for limited practice still apply in the case of a taxpayer's representative. So I would be able to represent like my own child. That's perfectly fine. I wouldn't have to be an enrolled agent in order to do that. So practice before the IRS. Now let me give you an example. Kimberly is an enrolled agent. She's an enrolled practitioner. A taxpayer named Lloyd hires her to represent him before the IRS during the examination of his tax return, which he self-prepared. So Lloyd did the TurboTax thing, and then he screwed something up along the way, and his return is being audited. So he doesn't want to go to the audit. Many times taxpayers are terrified of the IRS. That's really common for taxpayers to get, deer in the headlights. They don't even want to open the letter. I can't tell you how many times I've seen that happen too, where the taxpayer is so petrified of the IRS that they don't even want to open the letter. And many times the letter will just say something innocuous, like, oh, you have a refund coming, or, oh, yeah, we accepted your correspondence, or whatever. And they don't want to open it. They will bring you the letter closed because they're so scared. So it's not unusual for a taxpayer to not want to attend the audit. Lloyd, in this case, signs the Form 2848, indicating that Kimberly is now his authorized representative for all his tax affairs. Kimberly attends the examination on Lloyd's behalf, and he doesn't have to be there. Kimberly can represent him before all levels of the IRS because she's a licensed enrolled agent. So she has practice rights before all levels of the IRS, not just the examination division, but the appeals division as well. Now let's go over what is not practiced before the IRS. Practice before the IRS does not include representation of taxpayers before the U.S. Tax Court. So the U.S. Tax Court has its own rules of practice and its own rules regarding admission to practice. Attorneys are the only enrolled practitioners that can practice before the U.S. Tax Court without any additional, examination or licensing. So an attorney can practice before the U.S. Tax Court. An enrolled agent or a CPA may practice before the U.S. Tax Court if they take the U.S. Tax Court exam. So it is possible for enrolled agents and CPAs to practice before the U.S. Tax Court if they take and pass the U.S. Tax Court exam. It's a very difficult exam to pass. There's like a dozen or so people who pass it every single year, but it's not considered practice before the IRS because the U.S. Tax Court is a court. It's independent from the Internal Revenue Service. Merely appearing as a witness for the taxpayer is not considered practice before the IRS. In general, individuals who are not practitioners may appear before the IRS as witnesses, but they cannot advocate for the taxpayer. And then the preparation of a tax return is not considered practice before the IRS due to the outcome of the Loving case. So in Loving versus the IRS, a U.S. District Court found that the IRS lacked the authority to regulate tax preparers or the preparation of a tax return. So the preparation of a tax return is not considered practice before the IRS. And let me give you an example. James and Lenora are neighbors and lifelong friends. James is a retired bookkeeper and he prepares Lenora's tax return for free. Later, Lenora is audited by the IRS. James is not an enrolled practitioner and he cannot represent Lenora before the IRS. However, he is allowed to appear as a witness and provide information on her behalf, but James cannot advocate for his friend. So sometimes you will see this happen with taxpayers who might have English as a second language. They will request like a friend or a family member to go along with them to the IRS examination if they are representing themselves. And then in that case, that person can go along to translate. But it's not considered practice before the IRS if you're just assisting with translation, or in this case, it's, friends who are neighbors. And James is a retired bookkeeper. He's not an enrolled practitioner. And he prepared her tax return, and then, she can ask him, will you go with me to the examination? I'm just going to try to work it out myself. That's not considered practice before the IRS, but James wouldn't be able to advocate for his friend. Like he would, during the examination, he wouldn't be able to say, you don't have to answer that, or don't answer that question, or, tell the IRS to back off or anything like that. So he wouldn't be able to advocate for her, but he could certainly attend the examination appointment and offer information or translate or anything like that. That's permitted, but it's not considered practice before the IRS. Enrolled practitioners, only attorneys, CPAs, and EAs, which are enrolled agents, have unlimited rights to represent the taxpayers before the IRS by virtue of their licensing. So their licensing is what permits them to practice before the IRS. Now there's also limited practice rights by virtue of relationship. And we're going to go over that a little bit later in the webinar. But by virtue of your licensing, only attorneys, CPAs, and enrolled agents have unlimited practice rights. Now, enrolled retirement plan agents, which are sometimes this is shortened to ERPA, or enrolled actuaries are also authorized to practice before the IRS by virtue of their licensing. They are considered enrolled practitioners related to their area of expertise, primarily with those code sections governing employee retirement plans. Okay, but only attorneys, CPAs, and EAs have unlimited practice rights before all levels of the IRS by virtue of their licensing. You could represent a taxpayer even if you hadn't prepared that tax return, whether it was another preparer that prepared it or whether it was like a self-prepared tax return. You would be able to represent a taxpayer in an examination of that return, whether you prepared it or not, if you were one of these three at the top here in this paragraph. So attorneys, CPAs, and EAs. Sample quiz number 4. Which of the following actions would be considered practice before the IRS? A, advocating for a penalty abatement. B, the preparation of an original tax return. C, appearing before the IRS as a witness for a taxpayer. Or D, the preparation of a corporate tax return. I'll give you a couple of seconds there. The answer is A. Advocating for a penalty abatement would be considered practice before the IRS. Now let's talk about unenrolled tax preparers. Unenrolled tax preparers are tax professionals who prepare tax returns but do not have any type of licensing. Unenrolled tax preparers also include tax professionals that have an AFSP record of completion. So even if they participate in the annual filing season program, they're still considered unenrolled tax preparers. But if you do have an AFSP record of completion, you are allowed to engage in limited practice, but you're still considered an unenrolled preparer. PTIN holders without an AFSP record of completion or other professional credential are only permitted to prepare tax returns. They can't really do anything else. Unenrolled tax preparers cannot do any of the following. They cannot represent taxpayers before appeals officers, revenue officers, counsel, IRS counsel is what they're talking about, or similar officers or employees of the IRS or the Department of the Treasury. They cannot execute closing agreements. A closing agreement has to do with IRS examinations, basically. Let's say you have a client who has gone under audit and you're representing them before the IRS and you're an enrolled practitioner, you're a CPA or an EA. You could close the audit without the taxpayer being there. So you could execute and sign a closing agreement, assuming that you have the taxpayer's explicit permission to do that on the 2848 in order to represent them, right? You can represent the taxpayer before the IRS if you're an enrolled practitioner, but unenrolled tax preparers cannot do that. So they cannot sign any document on behalf of the taxpayer and they cannot execute closing agreements. It takes an enrolled practitioner in order to do that. An unenrolled tax preparer cannot extend the statutory period for tax assessments or the collection of tax. They cannot execute waivers. They cannot execute claims for a refund. And then once again, they can't sign any document on behalf of a taxpayer. So many times you will have unenrolled practitioners who will attempt to respond to notices on the taxpayer's behalf. But if they do respond to a notice on the taxpayer's behalf, I mean, they could certainly help the taxpayer write it, but they can't sign that note. They can't sign that response. They can't sign that letter on behalf of the taxpayer. An enrolled practitioner can. So generally, when I am representing a client and it's a correspondence audit and I'm corresponding with the IRS, I will have the taxpayer sign the letter, but I will sign it above their signature. So the IRS knows, hey, I'm representing this client. I'm the one that wrote this. Here's a copy of my 2848 as well. Enrolled practitioners can sign documents on behalf of taxpayers, but unenrolled practitioners cannot. That includes and that includes people who have an AFSP record of completion. They can't do any of these things, even if they have an AFSP certificate. AFSP certificate holders. Unenrolled tax return preparers that have current AFSP certificates may represent taxpayers in a limited capacity, but only during an IRS examination, so only before the examination division and not before appeals or any other IRS office, not before collections, just IRS examination. Of the taxable year or period covered by the tax return or claim for refund they themselves prepared and signed. So if you do have an AFSP certificate, then you can represent a taxpayer before the IRS examination division, but only if you yourself prepared that tax return. Enrolled practitioners, such as enrolled agents, can represent taxpayers before every level of the IRS, and they don't have to have prepared the tax return that's being examined. Many times, enrolled agents or CPAs are hired after a taxpayer has self-prepared their own return, like on TurboTax or something, and they've made a mistake. So enrolled practitioners can represent a taxpayer whether they prepared the return or not. But if it's an AFSP certificate holder, they can represent the taxpayer in a limited capacity, but only if they actually prepared the tax return in question. If the tax return was not prepared by that person, by that certificate holder, then you would not be able to represent the taxpayer before the IRS with regards to that particular tax return. The preparer must meet the AFSP certificate requirements, and one had a valid annual filing season program record of completion for the calendar year in which the tax return or claim for refund was prepared and signed, and two, has a valid annual filing season program record of completion for the year or years in which the representation occurs. Basically, what this means is that you have to have had an AFSP certificate in the year that the tax return was prepared, because many times examinations are not going to happen in the same year that the tax return was prepared. Taxpayers will get a notice that their tax return is being examined, usually, the following year or even sometimes 2 years later. So the preparer, if they are an unenrolled preparer, they have to have an AFSP certificate in the year that they actually prepared the return, and also have to have a valid AFSP certificate in the year in which the representation occurs. In order to obtain an annual filing season program record of completion, a return preparer must obtain 18 hours of CE from an IRS-approved CE provider. The hours must include a 6 credit hour annual federal tax refresher course, AFTR, that includes tax law updates. The AFTR course includes a required exam administered at the conclusion of the course by the CE provider. AFTR courses are offered by continuing education providers. They're not offered by the Internal Revenue Service. The Internal Revenue Service approves the CE providers and approves the courses, but the Internal Revenue Service doesn't actually offer AFTR courses. When the registered tax return preparer exam was still being offered back in 2012, right around there, the IRS actually used to administer that exam, but they don't administer this one. The AFTR courses are offered by CE providers, which are a third party, not by the IRS. Unenrolled preparers who have passed recognized state or national tests qualify for an exemption from the AFTR course, but still must obtain 15 hours of continuing education. So preparers who have AFSP certificates need to do ongoing continuing education. But if a person has like a recognized state or national test, an example of that would be the California Tax Education Council. There's California tax preparers, and if you have a California Registered Tax Preparer, CRTP or whatever it is, I was one of those many years ago, but now I can't remember all the verbiage that goes along with it. Initially, when I first started in this business, I was a California Registered Tax Preparer for a couple years, and then I went on to pass the enrolled agent exam, so I let it lapse. I mean, you don't need to be a California Registered Tax Preparer once you become an enrolled agent. The EA license trumps all of those state licenses. But if you do have a state license, then you are exempt from AFTR course. You don't have to take the course every year, which means you qualify for an exemption to the course, but you still have to do continuing education every year, 15 hours, if you qualify for one of these exemptions. The preparer must also annually renew their PTIN and consent to adhere to the obligations in Circular 230. All tax professionals that prepare tax returns for compensation have to have a PTIN, whether they have any kind of certificate, whether they're unenrolled, whether they're enrolled, it doesn't matter. If you prepare tax returns for compensation, you have to have a PTIN. It's mandatory. Now let me give you an example of the AFSP. Mohammed is an unenrolled tax preparer with a current AFSP certificate. He has always participated in the AFSP program from its inception. Mohammed prepared the personal and business tax returns for his client, Leo. In June, Leo receives an IRS notice, which is for the most recent personal income tax return that Mohammed prepared. Mohammed can respond to the notice and represent Leo before the examination division because he has a current AFSP certificate and he prepared the return. However, he cannot sign any document on Leo's behalf. Now, limited practice due to special relationship. This is a type of limited practice rights that taxpayers can have or practitioners can have, but it's not based on licensing. It's based on a special relationship. So some individuals may qualify to engage in limited practice before the IRS due to special relationship. However, these people are not referred to as enrolled practitioners. Now, an individual can always represent themselves. That's self-representation. A family member can also be represented by members of his or her immediate family. So I can represent my children, I can represent my parents, I can represent a sibling, and I wouldn't have to be an enrolled practitioner in that case. So you can represent members of your immediate family, and you still do need to have a 2848, but there's a special spot on the 2848 for you to fill it out if you are a family member representing another family member. In that case, you don't need to have any kind of special licensing, and you are allowed to represent a member of your own family basically before all levels of the IRS, but only that particular family member. Does that make sense? So in that case, you would have practice rights due to the relationship with that person. Like I would be able to represent my own kid before IRS collections or before IRS examination or before IRS appeals. That's fine because they're a member of my immediate family. Number 3 is an officer. This would be a bona fide officer of a corporation. Note that this does not say shareholder. A shareholder of a corporation cannot represent a corporation before the Internal Revenue Service unless that shareholder is also an officer. And by officer, we're talking about, the company president, the vice president, the treasurer, basically the officers that are listed on the annual list of officers. So for example, they're going to call it different things in different states, but in Nevada, they call it the annual list of officers and directors. And every corporation or LLC has to file one of those every single year. And you submit that information to the Secretary of State in Nevada. So I have experience with that. I submit that annual officer list for my corporation, my husband's corporation every single year. So like I said, it depends on the state what it's going to be called, but the officer of a corporation can represent a corporation before the Internal Revenue Service, but just a shareholder would not be able to do so if they were only a shareholder and not an officer. Now, with regards to partnerships, remember, corporations have shareholders and officers, and partnerships have partners. Okay, different verbiage. These are very different things. A partner in a partnership can represent the partnership before the IRS if it's a general partner. A limited partner cannot represent a partnership before the IRS. So it has to be a general partner. A general partner can sign the partnership return. A general partner can bind the partnership. For example, if the partnership needs to take out a business loan, then the general partner can sign that paperwork. But limited partners generally cannot bind the partnership, and they cannot represent the taxpayer. They cannot represent the entity itself, which is the partnership itself, before the IRS. An employee, a regular full-time employee, can represent their employer. Most of the time when you see this sort of thing, it's usually, in in-house accounting. An employee that is working for the company and works in the accounting department, for example, your bookkeeper or whoever's doing your payroll, they can represent their own employer if it's a full-time employee. There's actually a spot on the 2848 just for employees, even if it's a full-time employee and they need to represent their employer before the IRS. This is actually pretty commonplace, and most of the time it's because of a payroll issue. They'll be, filing the payroll tax returns or managing the payroll. They're running it through Gusto or ADP or whatever. and the IRS will send the employer a notice, and that employee can call the IRS and represent their own employer before the IRS, then request transcripts and whatever else they need to do, give information to the IRS, even advocate for the employer, like, oh, well, we made this deposit on time, I have proof of it right here, that sort of thing, if they need to do that. 99% of the time when I see this sort of thing, it's because of a payroll issue, and it's in-house accounting, and they're responding to some kind of payroll thing. A fiduciary. Now, there's many different types of fiduciaries that exist out there. This can include a trustee of a trust, okay, a trustee of a trust, an executor of an estate, a personal representative of an estate, an administrator, a receiver, or a guardian. A fiduciary can be any of these types of things. The IRS will sometimes use these terms interchangeably. A trustee is different than an executor, obviously, but these are all treated as fiduciaries, okay? And fiduciaries can represent the taxpayer or the entity that they are the fiduciary for before all levels of the IRS, okay? So, for example, let's say I wasn't an enrolled agent. I wasn't an enrolled practitioner, and my father passed away, and then I became the executor of his estate. I was named the executor of his estate, either in his will or by the courts or whatever. Then I would be able to represent my father's estate before all levels of the IRS as the executor. And I would be required to file any estate tax returns that were required to be filed. We're talking about the Form 1041 or the Form 706 if it applied. And then also I would be responsible for filing my father's final tax return if it was still outstanding. Like, for example, if he did have to file a Form 1040 and he passed away before it was filed, then I would be responsible for filing that return or hiring someone to file it, and then I would sign it, okay, if I was the executor of his estate. That's a fiduciary, okay? And I would have limited practice due to that special relationship. The special relationship that we're talking about here is the fiduciary relationship. I'm an executor, okay? And I wouldn't, whether I was an enrolled agent or not would not matter if I was actually named an executor by the courts. The IRS treats a fiduciary as if it's the taxpayer themselves. What that means is that the fiduciary is the one that's signing things. The fiduciary is the one that's like hiring accountants and lawyers. The fiduciary is the one that's making the decisions on what gets disbursed from the trust or the estate or whatever. The fiduciary is the one that's making all of those decisions. And this is true whether the taxpayer has died or whether it's a situation where it's like a guardian that has been named by the courts. Many times you'll have a situation where a person is a fiduciary for a living person. Like, let's say one of your parents is not deceased, but has Alzheimer's and can no longer manage their financial affairs. And then the court names you as their guardian or their receiver. Your parent is still alive, right? But they cannot sign their own tax returns. They can't, many times towards the end, if it's Alzheimer's, they don't recognize family members. They don't even know their own name. I've had several family members, unfortunately, with that disease. So in that case, a guardian sometimes has to be appointed. And then in that case, the IRS treats that guardian or that fiduciary as if it was the taxpayer themselves. Even if the taxpayer is still alive, they're not making any of their own financial decisions anymore. They're not signing anything anymore. So the IRS is going to treat the fiduciary as the taxpayer, okay? A qualifying student or law graduate working in an LITC or STCP, they are granted a special appearance authorization issued by the Taxpayer Advocate Service. So this is kind of a specific scenario. This is a low-income taxpayer clinic. So these are nonprofit clinics where taxpayers can come and receive tax advice, preparation. They can even receive representation sometimes from these students or law graduates, and then the people who are working in these clinics actually get valuable experience. But they're volunteers. These are unpaid. These are unpaid volunteers. and they're granted a special appearance authorization where they actually are allowed to represent taxpayers before the IRS, but it's only in their capacity as volunteers in these clinics. Now, the last one on the list is authorization for special appearances. I've personally never encountered this in practice myself. I do know that it exists. The only examples that I've ever seen have been like for military personnel. So in rare circumstances, the commissioner of the IRS or a delegate will authorize a person who is not otherwise eligible to practice before the IRS to represent another person for a particular matter. The request is made to the Office of Professional Responsibility. If granted, the written consent will detail the specific circumstances related to the appearance. And like I said, the only time that I've ever seen an example of this was for military personnel. The example that I read, it was several years ago actually, the example that I read was a situation where either it was like a partner, like a girlfriend or a boyfriend that had a power of attorney, but it was like a durable power of attorney. It wasn't an IRS power of attorney. And they were permitted to represent their like loved one before the IRS while the taxpayer was actually in the military or serving in a combat zone or something like that. So that's the only example that I've actually ever seen. And it wasn't something that I had specific experience with, but I kind of wanted you to understand how that might actually work. Authorization for special appearances is a pretty rare thing. The request has to go through the IRS. They have to grant that request. And then the consent, the written consent, will detail the specific circumstances related to the appearance. Okay, so these are examples of limited practice due to special relationship, not due to licensing. Remember, if you're an enrolled agent, a CPA, or an attorney, you have unlimited practice rights due to your licensing. And in these examples that I'm giving here, it's limited practice due to special relationship, not having to do with licensing. All right, now I'm going to give you several examples of limited practice. Example number 1. Donald was a tax attorney who was disbarred because of felony embezzlement. So he actually was a tax practitioner. He was an attorney, and then he was disbarred. He was stripped of his license. A disbarred individual is not eligible to represent other taxpayers before the IRS. Donald was audited by the IRS during the year. That's actually no surprise. Many times if you have someone who's a tax attorney or a CPA or an EA and they get disbarred, they're going to get audited too, because the IRS knows that they're doing something hinky, and they're gonna audit those people. Despite being disbarred, Donald may still represent himself before the IRS. Of course, you can do pro se. Pro se means you're representing yourself during the examination of his own return. Donald may also represent a close family member like his own child or his spouse. Although if he chooses to represent his own child or his spouse, I don't think he's going to be doing them any favors. If he's a disbarred attorney, I feel like the IRS might not go easy on them in that case. Maybe hire somebody else instead. Okay, example number 2. Leah is a 21-year-old accounting student. So she's an accounting student. She knows about accounting, but she doesn't have any kind of licensing yet. She's not an enrolled practitioner. Leah lives with her brother, Brandon, who is 32 and self-employed. Leah prepares her brother's tax return. Brandon is later audited by the IRS. Leah may represent her brother before the IRS if Brandon signs a Form 2848 granting his sister representation rights. So he's an adult. He would have to sign a Form 2848 in order to allow his sister to represent him. But it's perfectly fine. There's a place on the 2848 for family members to represent other family members. And since she's a sibling, she can represent her brother. Leah will have all the rights that an enrolled practitioner would have, but only with respect to her brother's tax issues. So she can represent her own brother, and that's the limited practice rights that she has. Okay, even though she's just an accounting student and she's not an enrolled practitioner, she can represent her own brother. That's fine, but not anybody else. Okay. Example number 3. Nicolette is a full-time payroll bookkeeper for her employer, Green Lawn Landscaping. The IRS sent her employer a notice regarding some delinquent payroll tax returns. Nicolette may file Form 2848, Power of Attorney, and Declaration of Representative, and speak with the IRS on her employer's behalf. Even though Nicolette is not an enrolled preparer, she may represent Green Lawn Landscaping before the IRS because of the employee-employer relationship. And once again, there's a spot on the 2848 for full-time employees to represent their employers. So this is fine. And usually, as I said before in the last slide, it usually has to do with a payroll tax issue. Now let's talk about conflicts of interest. Conflicts of interest are commonplace, especially when it comes to a divorce. There are special rules that apply to tax practitioners with regards to conflicts of interest between two clients. If there is a potential conflict of interest, the practitioner must disclose the conflict and be given the opportunity to disclose all material facts. A practitioner will have a conflict of interest if the representation of one client will be directly adverse to another client, or if there's a significant risk that the representation of one or more clients will be materially limited by the practitioner's responsibilities to another client, a former client, a third person, or by a personal interest of the practitioner. And I'm going to give you some examples of this. Now, under Circular 230, you can still represent a client when a conflict of interest exists if all of the three following statements are true. They all have to be true. The practitioner reasonably believes that he or she will be able to provide competent and diligent representation to each affected client. The representation cannot be prohibited by law, and each affected client must waive the conflict of interest and give informed consent confirmed in writing. So you have to have the clients, the affected clients. For example, if it is a divorce, let's say it's a divorce, or clients are going through a divorce, and they still want you to prepare their tax returns or represent them in an examination, but they're going through a divorce. So there's obviously a conflict of interest there. You have to have each affected client waive the conflict of interest in writing. They have to sign a conflict of interest waiver. Just telling them orally, like with your mouth, is not enough, or sending them an email or whatever, a text, it's not enough. Each affected client has to give informed consent, and they have to waive the conflict of interest in writing. They have to sign a conflict of interest waiver. Regulations allow the written consent to be made within a reasonable period after the informed consent, but not later than 30 days after the date on which the conflict is known by the practitioner. So for example, if you've discovered that they were going through a divorce, or they told you, and they're both your clients, then you want to give them that conflict of interest waiver within 30 days after you discover the conflict, or you're told about the conflict. The written consent must be retained for at least 36 months from the date the representation ends, and must be given to any officer or employee of the IRS if requested. So you have to keep that written conflict of interest waiver in your records, in your practitioner records, for at least 36 months, so 3 years. Conflicts of interest can arise from a number of different scenarios. Personally, the most common type of conflict of interest that I have encountered are divorcing couples. Personally, that's the type of conflict that I have the most experience with. To be honest, I generally do not keep both spouses as clients if they are divorcing. If you don't keep both spouses as clients, then of course you wouldn't need a conflict of interest waiver. Divorcing couples are probably the most common type of conflict of interest that you're going to encounter. But it doesn't always have to be a divorcing couple. Married couples filing jointly that are not divorcing, especially if they're like physically separated but not planning on divorcing, sometimes you will have a situation where a married couple that's filing jointly and is not in the midst of a divorce will have a conflict of interest. I've seen it on more than one occasion, although it's not, let's not say it's commonplace. at least in my experience. I've seen it on more than one occasion, though, where you have a couple that is filing jointly, but the tax scenario for one spouse would be substantially better for that one spouse if that spouse filed MFS. And sometimes spouses will choose to keep their money separate, but they will still choose to file jointly because of the tax savings that it affords to them, or the ease of filing. It's just easier to file jointly rather than filing two separate returns. But sometimes you will have a scenario where one spouse will actually be getting a larger refund or have a smaller amount of tax due if they file separately from the other spouse. I've seen this personally, like on a handful of occasions, where you have a married couple, and it's usually when one spouse is a very high earner and the other spouse makes less money than the other one, and substantially less money than the other one, where if they are to file jointly, then sometimes they will lose their itemized deductions because they're filing jointly and their AGI is too high, or they're going to be subject to the AMT or whatever because of the high income earner. Okay. Invariably, sometimes those spouses will say, oh, can you run it both ways? Run it both ways means, okay, let's run this MFS, married filing separate, as well as married filing joint. If they want me to do that, I'm happy to do that. If they pay me for the service, and I'll run it both ways. And I'll say, okay, well, this is your tax result if you file separate returns, and this is your tax result if you file jointly. And at least a few times I've had a situation where the spouse that's the lower earning spouse or the lower income spouse will say, well, I don't want to file jointly with my husband or my wife, because if I filed a separate return from him or her, I'm going to get a refund. But then if I file jointly with my spouse, then we're going to owe a bunch of tax, because that high income earner, their business made a huge amount of money, or they are making, $300,000 or $400,000 a year, and the other one's a teacher. So they feel like they want to file separately from that person so they can have their own little refund deposited into their own little bank account, and they want to let their spouse kind of deal with that huge tax bill for their own income. Okay, so I've had that happen. And of course, the higher income spouse never likes that very much. So that's an obvious conflict of interest. When you have spouses who are filing jointly and their tax scenario is significantly different when they file MFS, especially if it significantly impacts one spouse more than the other. Sometimes you'll have that happen too. And then you have to bust out that conflict of interest waiver if you decide to keep them both. So I've had that happen too. Now, you can have conflicts between entities and their owners, or sometimes co-owners of an entity. I say co-owners because, if it's a partnership, then it's partners. And if it is a corporation, then it's, the shareholders or the officers of that corporation. Many times, if you have a business where there's multiple owners, they will have a falling out, and then you'll have a conflict of interest between the entity and the owners, as well as the owners of that entity. So that's not uncommon either. Trusts and their beneficiaries, estates and their beneficiaries, and then conflicts of interest between family members. Now, conflicts with trusts and estates and their beneficiaries are actually pretty common too. How many times have you heard of a situation where, someone passes away and they have money, and the assets pass to the estate? And I've seen this happen a number of times too. The assets pass to the estate, and let's say it's someone who is relatively wealthy, and then they have like 4 or 5 children, and the children are all equal beneficiaries of the estate, but only one child. Usually the parent will choose like the responsible one or the older one or whatever. That particular child will be chosen as the executor in the decedent's will. And then the other kids, many times they'll get angry because they feel like maybe the money that they have coming to them is not coming fast enough. The executor, they think they're hiding stuff. They feel like the will is not correct or whatever reason. These types of conflicts are pretty commonplace too. So trusts in their beneficiaries and estates in their beneficiaries. Often when someone dies, especially if they have money, cash, or other assets like stock or real estate, then the beneficiaries will start to argue with one another. And then you have a conflict there too. And then you can also have conflicts of interest between family members, even not necessarily spouses. Sometimes family members will run a business together and you'll have a conflict there. And sometimes you can have conflicts between family members where it's like a parent and their own child, usually an adult child. I've had it happen where a parent wanted to claim a child who was already a legal adult and in college. I've had this happen a handful of times as well. The child was not a minor anymore, and they're in college, and many times that child will say, I'm supporting myself, I'm not living at home, I'm paying my own way, the loans are in my name, my student loans are in my name, and my dad or my mom still wants to claim me, but they're not supporting me. Okay, and then you go and you talk to the parent, and of course the parent has a different story, right? Oh yeah, I am supporting my son or my daughter, I'm going to claim them on my tax return this year, and then you have an obvious conflict of interest. Usually when that happens, it's very difficult to keep both of those clients. That is an obvious conflict of interest, but you can't file a tax return for a kid or an adult child and then have him claim him or her, have him claim their own exemption, file as single, and then also have the parent claim that child as a dependent. You can't do that. You know that one of those is going to get rejected. So that's an example of a conflict of interest as well. And at least in my case, generally in the couple of scenarios that I've had like that, I usually will side with the child if I can tell that the child is like earning their own income and living on their own. It might be 21 or 22. They're full-time students, but they're paying their own way. They're not even living at home anymore. On one occasion, which I've talked about in other webinars, on one occasion, I had a very bad experience with a mother who was the client of a CPA firm that I was working for. And she was attempting to claim her own son, who was still a full-time student and under the age of 24. So potentially he could have qualified as a qualifying child, but the adult child, can't remember if he was 22 or 23 or whatever, already had his own kid. He was already an adult with his own child, and he had a job and an apartment, and he was living with his girlfriend. So, it was ridiculous for the mother to be claiming him as a qualifying child on her return. And I remember very distinctly that the mother screamed at me over the phone and then threatened to sue me. That actually happened. And of course, we couldn't keep her as a client anymore. And I wouldn't have wanted to keep her as a client. But in that case, sometimes the conflict is not going to be resolved. It's not resolvable. And you will not be able to represent both of them, or you will not be able to keep both of them as clients. Sometimes that happens too. Okay. Now, let me give you a couple of examples of a conflict of interest. Jenny and Paul are siblings who are business partners in Superfoods LLC, which is taxed as a partnership. Daniel is an enrolled agent who prepares both their partnership return and their individual returns. So these are siblings. This is not a married couple, but they're going to have a problem. During the year, Jenny and Paul have a major disagreement about the direction of their business. So remember, it's a partnership. They're siblings, and they have a falling out. Daniel must prepare a conflict of interest waiver for each partner. So the partners are Jenny and Paul, as well as the partnership itself, if he plans to keep them both as clients. Okay, so he's preparing their personal income tax returns, but he's also preparing the partnership tax return, and they're having a falling out. So they're going to dissolve the partnership, but presumably they still want Daniel to be preparing their tax returns and also preparing the partnership tax return. So he has to get a conflict of interest waiver from the partners as well as from the partnership itself, which is the entity. And that this would hold true if it was another type of entity, such as a corporation as well. Okay. Example number 2. Penny is an EA who has always prepared tax returns for Dora and Samuel, a married couple. Dora and Samuel go through a contentious divorce, and Penny believes there is a potential for conflict of interest relating to the services she would provide for each of them. She prepares a written statement explaining the potential conflict of interest and reviews it with her clients. Dora and Samuel still want Penny to prepare their returns, and Penny determines that she will be able to represent each fairly and competently. Sometimes this isn't the case. Sometimes, even if they've been your long-term clients and there's a conflict of interest, sometimes you are not able to represent each of them fairly because the conflict is too great. And this is especially true if you have one situation where the divorce is contentious, and sometimes one spouse will come in and ask you for things that you're not allowed to give them. Like, oh, give me, I'm going through a divorce with John, and I want all of the records of his business. I want to know how much money he's making. Give me his payroll tax returns and all this other stuff. That can be really problematic. And sometimes you are not able to represent both of them fairly, and you have to let one or both of them go as clients. But if you do decide to keep them both, and it is a divorce, then they have to sign a conflict of interest waiver. So Penny, who is the EA in this case, has both Dora and Samuel sign the statement that waives the conflict and gives their consent for her to prepare their individual tax returns. Penny must retain the record of their consent for at least 36 months after she last represents either party. And you can look these up online. You just look for conflict of interest waiver or Circular 230 conflict of interest waiver. They're pretty easy to find. Some practices will have different conflict of interest waivers for a divorce, for a business conflict, whatever. It's pretty easy to find these online, and you can download them and use them in your own practice, modify them for your own use. We're going to close out this webinar with a final quiz. Jenny, an enrolled agent, represented her client, Thomas, and his former spouse, Karen, before the Internal Revenue Service with regard to a tax matter. Karen and Thomas divorced last year, and their divorce was amicable. So they used to be married, and now they're divorced, and Jenny, who is the enrolled agent, represented them in a tax matter. It's not uncommon for you to have a situation where you might be representing a divorced couple. They're divorced now, but they weren't divorced in the past, and they filed a joint tax return, MFJ, and that joint tax return has come under audit, and it's not uncommon for you to be representing both spouses in that case. That's okay. However, there is an obvious conflict of interest if the spouses have now divorced. So due to the potential conflict of interest, Jenny obtained a written consent from each of her clients, both Karen and Thomas, waiving the conflict of interest and giving informed consent. So she would need to have a conflict of interest waiver for each one of them, a separate conflict of interest waiver for Karen, and a separate one for Thomas. And they both have to sign the conflict of interest waiver. It has to be in writing. Jenny must keep these written consents for how long after the conclusion of the representation? A, 1 year, B, 36 months, C, 48 months, and D is 60 months, which is 5 years. And I'll give you a few seconds to decide on the answer. And the answer is B, which is 36 months. So Jenny, who is the enrolled agent, would be required to keep that conflict of interest waiver for 36 months. This is a record-keeping requirement for the practitioner, not for the taxpayers themselves. So 36 months is how long she has to hold on to that conflict of interest waiver for both spouses. Now here are some useful Circular 230 links. This is the link to the actual circular on the IRS website. And then another document on the IRS website that discusses Circular 230 best practices. That's the second link on this slide. And I hope you enjoyed this Circular 230 webinar. We've reached the end. Have a great day, everyone.